This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hey everyone, I'm Leonard French, your favorite copyright attorney, and I have an update in the Akilah Hughes versus Carl Benjamin, aka Sargon of Akkad case. If you recall, Sargon won the case. His use was a fair use, and his attorney, Wesley Mullen, made a motion for attorney's fees and costs for about $33,419 in attorney's fees and costs. Now, I'm not sure if you're aware how this actually works, but first, Sargon's attorney makes a motion for attorney's fees and costs. Note the date here, 2/18/20, so February 18th, 2020. And then Akilah Hughes made her opposition 14 days later on March 4th. And then you might not be aware, but there is an opportunity for Sargon to respond, or we call it a reply. It's a motion and then a response in opposition and then a reply. And the law actually allows for that, but then it ends there. So this is the final reply then has been filed here March 11th. And so I thought that we should bring this to you as these have been popular for you before. Before we get there, you should be aware that this is fairly complicated. Not only do you have to know the federal rules of civil procedure, but you also have to know the local rules of the United States District Court for the Southern District of New York in this case. And then you have to know the judge's individual rules and practices. Fortunately, you only have to go back to the local rules to find the section 6.1 here that says that on all civil motions, the motion should be filed, and then any opposing affidavits or answering memoranda should be filed within 14 days, and then reply affidavits are filed within 7 days. So that's where that comes from. So just a really quick summary here. The memorandum of law in support of attorney's fees and costs asked for $33,419. And then Akilah Hughes responded in opposition saying that she didn't think she had to pay that. And so here we're going to find out what Sargon of Akkad, through their attorney, Wesley Mullen, has to say about that. Defendant respectfully submits this reply memoranda. Plaintiff's claims were objectively unreasonable. That's one of the standards for getting your fees and costs returned. Plaintiff's claims were objectively unreasonable because the fair use defense clearly applies on the face of the complaint. Objective unreasonableness carries substantial weight when awarding fees under Section 505 of the Copyright Act. The opposition responds that plaintiff sued upon the guidance of her former counsel and with a subjective good faith belief that her claims had merit. Well, I'm not sure if you're aware, but the subjective good faith belief is the 17 U.S.C. 512F standard, which is the DMCA misrepresentation standard. I'm not sure it really applies to a argument for fees and costs under the fee shifting provision in Section 505 of the Copyright Act, which says that a prevailing party may be awarded their fees and costs at the discretion of the presiding judge. Those arguments are misplaced. Well, isn't that what I just said? Because Fogarty and Kurtzsang, the two cases, prescribe an objective test, not a subjective one. Like I said, 512F is a subjective test. 505 is Fogarty and Kurtzsang. And he cites to Mallory versus NBC Universal, finding that where copyright claims are objectively unreasonable, plaintiff's professed subjective belief to the contrary is entitled no weight. And then also citing Little v. 20th Century Fox Corporation, awarding fees under Section 505 because even if pursued in subjective good faith belief by the plaintiffs, the claim was objectively unreasonable. So again, the DMCA 512F misrepresentation standard does not apply to 505 fee shifting. Thus, even accepting the argument that plaintiffs' claims and conduct were non-frivolous and taken in good faith, a finding of objective unreasonableness is still appropriate. A claim that is not frivolous may still be objectively unreasonable. Frivolous is not a prerequisite to an award under 505. The opposition also argues that plaintiff should not pay because fair use ordinarily requires a case-by-case analysis. That weighs in favor of fees, not against them. Fair use is a close, factual call in plenty of cases, but in the exceptional case, like this one, when it is clear from the face of the complaint that a defendant copied for the transformative purposes of criticism and commentary, pursuit of an infringement claim is unreasonable, speech-chilling, and contrary to the purposes of the Copyright Act. Finally, the opposition claims that plaintiff litigated reasonably because she offered to settle her claims for $46,000 10 days before defendant's motion to dismiss was due. It makes no effort to justify a $46,000 price tag on claims that the court warned were likely to be dismissed. And the assertion that defendant made no attempts to resolve the matter is unfaithful. To the record, defendant made early efforts to settle and promised to seek fees when plaintiff ignored him. Plaintiff's motivations were improper because she used the lawsuit to silence criticism for self-promotion and to leverage the settlement of meritless claims. Years of public taunts prove plaintiff's purposes. And you can go back to those videos and see she definitely made lots of taunts. She was going to bankrupt him, she was going to censor him, stuff like that. The opposition hardly denies it. Instead, citing no authority, it asserts that plaintiff's conduct is irrelevant. To the contrary, circumstantial evidence that a copyright claim was not brought because of its inherent merit is properly considered a motion for fees under Section 505. The opposition also attempts to minimize plaintiff's conduct as heat-of-the-moment banter between plaintiff and defendant. That rings hollow because plaintiff has been caught up in the heat of the moment for the better part of 2 years, citing footnote 1, plaintiff's August 2017 video announcing the lawsuit, saying, "I don't care, they're not my kids, let's bankrupt this person." Nor was it banter between the parties. Plaintiff's performance was a one-woman show. While she hyped this lawsuit on social media, defendant ploddingly litigated his defense before the court. When an action is objectively unreasonable, the interest of compensation is compelling. That compelling interest endures even where a prevailing party raised money to fund the defense of an objectively unreasonable claim by a publicity-seeking plaintiff. The opposition argues that Section 505 should not apply because Sargon earned a surplus after plaintiff sued him, but it offers no reason fees should be reduced by collateral source payments. Its sole case highlights how compensation is served by awarding fees to prevailing copyright defendants who, like Sargon, are not entitled to compensatory damages. See NFL versus Primetime 24, declining to award fees where plaintiff was appropriately compensated by a $2.5 million damage award that serves as sufficient deterrence. In sum, adopting the opposition's logic would arbitrarily relieve unreasonable, inappropriately motivated actors of accountability based on third-party conduct. The opposition argues, in effect, that plaintiff has so dearly suffered by way of widespread public criticism that an award of fees would have no further deterrent effect, but the criticism is not punishment. It is an earned result of plaintiff's unreasonable conduct. Financial deterrence is still warranted, and it is especially warranted here where one of plaintiff's motivations was publicity. See the Fortgang case, awarding fees against a publicity-seeking copyright plaintiff driven by vanity and a desire to harass the defendants. It is entirely conceivable that the widespread criticism plaintiff claims to have borne as a result of her lawsuit will rebound to her financial benefit in the form of likes, subscriptions, followers, and royalties. In any event, plaintiff does not claim an inability to pay because the opposition does not aver that plaintiff lacks resources or argue a disparity in the parties' financial circumstances. A reduction in the award of fees would be appropriate. See Harold v. van der Plas. Failure to provide financial information prevents the court from exercising its discretion to reduce the fee award. So note that. You have to provide your financial information. And another case, Sarah Designs, a case declining to reduce fees under 505 where plaintiff offered only vague and conclusory declarations of inability to pay. Defendant seeks $33,545 inclusive of fees and costs, plus approximately $5,000 for the costs of this motion. We'll see that in a moment. Plaintiff does not contest reasonableness. The request is consistent with comparable awards to prevailing defendants. See Pickett v. Mygos Touring, recommending an award of $451,000 to a copyright defendant who prevailed on a motion to dismiss. And see Amains v. Adeyemi, awarding $42,000 to copyright defendants who prevailed on a motion to dismiss. And Fortgang, recommending an award of $102,000 to copyright defendants who prevailed on a motion to dismiss. The amount should be awarded in full. For the reasons stated, defendant respectfully requests the court award $38,545.89 in costs and attorney's fees pursuant to 17 U.S.C. 505. And that's the end of that motion, but not the end of the filing. For there is this declaration by Wesley Mullen, who is Sargon's attorney. They attached Exhibit A as a detailed invoice, which was redacted for privacy, and he certifies his rates are accurate and reasonable. Let's take a look at this Exhibit A invoice. If you ever wondered what an invoice from your attorney looks like, it looks very much like this. This kind of looks like it was prepared in a Clio style. Maybe Clio is the software that was used, because this is what my invoices looked like when I used Clio. Now we got rid of Clio because it ended up being like $100 a month, and we could really save that and just use other invoicing programs that were free. So starting February 3rd, 2020, review decision and order granting motion to dismiss, correspondence with client, review opinion and order, or correspondence with client, attention to clerk's judgment, research attorney's fees, email correspondent to Carl Benjamin, re-attorney's fees, email correspondence again, draft and review the motion for fees. So you can see the amount of time that's being put in here. Here's 2.6 hours for drafting, 1.1 hours for drafting, 1.6 hours for drafting, 2.2 hours for drafting, 5.3 hours to finalize, and then he gave a 50% discount on that one. I'm not sure why I can't highlight this. There we go. And then review courtesy copy, draft letters to chambers, color copies, printing, messenger fees, for a total of $5,366, which is remarkably close to the estimated $5,000. And then there will be this current invoice, what's due, whether any payments were received. If there was money in a trust account, you'd see that accounted for here. So that's what we're looking at. So that's the $38,000 now that Sargon is asking for from Akilah Hughes. If she couldn't pay it, she apparently should have said so to the court in her response in opposition. So I'm guessing that she either has the money or forgot to do that part. There's one possible next step. Well, there's two, but there's one optional next step. If Attorney Grant, who is Akilah Hughes' attorney, if there is some reason to file yet another reply, she can ask for leave from the court, permission from the court to file something more called a Sir reply. And I thought I would just look this up for you. What does a Sir reply mean? It means an extra reply or an excessive reply. And since it's excessive or super or over the top or too much, you have to ask permission from the court to file an extra reply. So if they make a motion to file an extra reply, we'll go over that. Otherwise, the next step is for the judge to rule on all of this, and we'll find out exactly how much the judge is going to grant to Sargon. And that will be the end of the case, unless there is some kind of appeal, which I doubt there will be some kind of appeal. So what do you think of that? Let us know in the comments below. I thought it was a very well-prepared motion, and I'm impressed with the work that Attorney Mullen does. And that's that. That's the Sargon of Akkad and Akilah Hughes case, minus the final court ruling on the $38,000 motion for fees and costs. Let us know what you think. Now, we could only bring these rulings to you with the financial support that we receive from our patrons and sponsors and supporters from the various channels and avenues and revenue streams that we are able to set up here. So thank you very much to our patreon.com/LJFrench supporters and our sponsors.com/law supporters. We also turned on YouTube memberships. Look below if you've been waiting for that. We have 3 tiers set up for you. you. We really appreciate your support. At the $50 level in the month of March, thank you to Wes, Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Ottah, Cute Grills in your area, Longreach Jones, Zachary Chaney, Mullen PC, that's Sargon's attorney, and Anders Thorenfeldt. And we really appreciate the $5 plus supporters who will be scrolling on the screen in front of me. All of these announced supporters will be in the description of the videos that drop. I'm going to put some dog video here for you for your enjoyment. I'm Leonard French, your favorite copyright attorney. I love you all, and I'll see you in the next one. Bye. Where's the ball? No, you can't have that ball. No, you can't have that ball. You already have two. You already have two balls in your beak there. Yeah, see, look, there's two. 1, 2. Ah, I got it. I got to it before you did. Look, it's Orion's belt.